Thank you for watching. Welcome back to Conversations with Jennifer. Jennifer's an estate planning attorney, and today we are going to cover what happens if you move and what do you do with your estate planning documents.
Okay.
So, Jennifer, what happens to your estate plan if you move?
Yeah, so your estate plan, essentially just by moving to another state, your estate plan is still valid. It doesn't become ineffective just because you've moved to another state. However, there's a few things that we always recommend clients to do. So one is meet with a local estate planning attorney in that state. If you have a trust in place, the goal will be all that work that you already did in creating the trust and moving your assets into the name of the trust, you won't have to redo. But it's a good idea just to meet with an attorney and see if any provisions inside the trust need to be updated just through an amendment or a restatement. So you won't have to redo all of that funding or the trust transfers at all. So that's great. But meet with an attorney, make sure the provisions still work, particularly if you are spouses. Certain states here in the US, like California, we're a community property state.
Yeah.
Other states are not. And so if you move to that state, what does that mean from a marital property perspective, and whether or not it's important to update the provisions in your trust dealing with marital properties. So definitely, meet with an attorney on the trust side, but hopefully all your funding will not need to be redone. For the other documents, like your healthcare directive and your financial power of attorney and your will, we always recommend just redoing those, just restating them at the new state level. Every state has really different provisions in place as far as powers of attorney or healthcare decisions, different provisions that you may want to take advantage of, different provisions that don't exist in that new state. But again, the new attorney may say, nope, everything's fine. Everything still works here, which I do with clients of mine. So certainly I have clients who have moved to other states, and that's what I always recommend, meet with an attorney in that new state. I've had other clients move here to California. I just talked to clients earlier today who were new to California from Oklahoma. And their attorney told them the same thing. Meet with local counsel in California now that you've moved there. And we may make changes, we may not. So it's just a matter of taking a look at all of the documents to see what you need to update. But again, it's really more important if you're married and you're moving to a non-community property state, or if you're dealing with healthcare decisions or financial powers of attorney. I think we've talked about this in the past. Financial powers of attorney are always so problematic, I find. Yeah. And you probably, Amar, see that on your side of things as well. It's always better to get kind of the state approved or the form that everyone in that state is familiar with seeing, because they're already problematic on their own. But if you also have a form that's created in another state or looks different than what they're used to looking at, it can create some problems for you. And those tend to be real easy documents to update. But hopefully the trust structure you've put in place can stay in place.
Yeah, having the trust structure staying in place is key, so you don't have to retitle all those accounts. Correct. And all that. So that relieves some of the headaches. What if you're somebody that's like a snowbird? You live in Boston X amount of the time, or let's use Illinois. Let's say you're in Chicago for a couple months out of the year, and then you're coming to, let's say, Los Angeles for a couple months out of the year, and then traveling other times. Does that complicate things? Do you need to have documents for each one of the states for like the healthcare directive, power of attorney type stuff? And then where do you consider home base?
Yep. Yeah. So every state has their own rules in place as far as, if you're considered a resident of that state. As far as like your trust and your will, I wouldn't worry about updating that. You really just want to make sure wherever your kind of considered permanent residence is from an income tax perspective, as long as you have documents in place there, that's good. But I do have some elderly clients or clients with health concerns or health issues, and they will sometimes have powers or advanced healthcare directives in both states, so that their doctors have that in both medical providers have the documents in place. So I do have some clients who do that, but those, I would say, for the most part, are more clients who have a lot more health concerns and are more concerned about something happening to them in those states. But otherwise, if you have one that you created in California, but you spend a couple of months out of the year in Colorado or Illinois or back east, I wouldn't worry about creating a separate document in those states necessarily. It's more of the elderly or the ones with health issues.
Sounds good. So if you're moving to California from outside of California to California and you're wondering if your healthcare directives or power of attorney still make sense, please reach out to Jennifer or myself from a financial planning standpoint, and we'd be happy to help. If you like this type of content, if you could please hit like and subscribe, it helps other people find our content. And thank you for watching. Thank you, Jennifer.
Have a great day.
Yep.